Welcome back to our class on drafting a power of attorney. In the previous video, we enumerated the parts and clauses of a power of attorney. So make sure that if you are asked to list the clauses, you list them in their correct order and not just randomly. So you will write that the clauses in a power of attorney include one, commencement clause, followed by the date, recitals, appointment clause, power clause, Omnibus clause, irrevocability clause, testimonium, execution clause, attestation, and then franking. So now that we have identified the clauses, we'll go further to discuss in this video the function of each clause and also show how each of them is properly drafted. So let's start with the first clause, which is the commencement clause. So, what is the function of the commencement clause in relation to power of attorney? The commencement clause serves the function of disclosing the nature of the document. In law, we know that there are plethoras of documents. You have court processes, right? You have a will, you have deed of assignment, you have a lease, you have deed of legal mortgage. So how do you as a lawyer identify a document to be a power of attorney? It is to look at the commencement clause. So the commencement clause is like giving a document a face, a character, a name. So imagine somebody says, I saw my friend yesterday. That my friend. I've missed him. Oh, that my friend. No, the next question you ask is, what is the name of your friend, or who is the friend? And then you say, oh, that friend is Campos. Oh, is right. So you give that friend a name, right? So the commencement clause is like the name of that legal document. It gives it a character such that it becomes easy to distinguish it from other legal documents. And please take note that the commencement clause is to be written in capital letters, because the idea is that it is mind grabbing, such that anybody that sees it will know that, oh, this is a power of attorney. So please don't write it in sentence case, right? Ensure that you write everything in capital letters. So let's look at the way to draft the commencement clause by this power of attorney, or this power of attorney. So clearly you can see that there are two options. Option one, you have by this power of attorney, and then option two, this power of attorney. And you may be wondering, when do I use option one and when do I go for option two? Option one is best suitable when the power of attorney would not include a recital clause. But you should go for option two, which is this power of attorney, when the power of attorney would include a recital. So as we proceed, you are going to see the importance of this particular option one and option two, even when it relates to the date clause and the recital. For me, I believe that for purpose of proper grammatical construction, even you need to know when to use the first option and the second option. So when the document would not include a recital, you write by this power of attorney. But once that power of attorney would include a recital, it is best you write this power of attorney. So now that you know the function of the commencement clause, which is that it helps you to distinguish this document from other legal documents, let's look at the next clause, which is the date clause. Of course, date will always include what? The day, the month, and the year. So, how is this important to a power of attorney? Let's recall again that the purpose of creating a power of attorney is so that the donor can empower the donee to act on his behalf. So the question is, without the date clause, how then would we establish the date of commencement of the authority of the donee to act on behalf of the donor? So the date clause is very important to a power of attorney because it will help us establish the commencement of authority, such that if a third party is dealing with the donee, the third party is not skeptical or confused as to when exactly the donor authorized the donee to start to act on his behalf. Also, the date clause helps to determine the date of registration. Generally, I explained in that main tutorial video that a power of attorney, as that document and transaction, is not a registrable instrument unless the land registration law of that particular state says that power of attorney is a registrable instrument. And we were able to identify that in Lagos state jurisdiction, power of attorney is a registrable instrument. What that implies is the moment that power of attorney is dated, it then determines the date of registration. Of course, we should know that it is 60 days from the date of execution. But you also know that in law, the law presumes that the date on a particular deed is the same date it was executed. So usually deeds are usually left undated, right? So that you can avoid the incidence of law, right? So, however, the moment that deed is dated, then the law presumes that that was a day that deed was also what executed, which is why the law will calculate the 60 days from the date of execution, which is actually the date on that particular deed. So, the moment this power of attorney is dated, apart from establishing the commencement of authority, it then helps us to calculate the time frame of registration. The moment that particular power of attorney is a registrable instrument in that particular property law jurisdiction. In addition, we can also say that if the date clause helps to establish the commencement of authority, then it can also help us to calculate the duration of the power of attorney, right? Such that it is intended to last for a specific period. Let's say, for example, a power of attorney is made irrevocable for a period of 8 months from the date of execution. What that implies is, let's say the date on the power of attorney is the 1st of May. How then do you calculate the 8 months? Don't forget, the execution is directly linked to the date on that deed, right? So, 8 months from the day of execution will be calculated from the 1st of May, right? To say this is when this power will be terminated, such that the donee can no longer act for the donor. So you can see that the date clause is a very, very important aspect of a power of attorney. Take note, if you are given a scenario where the day, the month, and the year is provided, and you are told to draft the introductory part of that power of attorney, ensure that you use the date on the scenario. But if no date is given, use the day of your bar finals to, as the date you prepared the power of attorney and when the authority is supposed to commence. Let's look at how to, excuse me, let's look at how to draft the date clause of a power of attorney. By this power of attorney, known as commencement clause, made this 15th day of January 2025. So, these aspects in blue, which you will notice as what I will use to discuss when I'm talking about a specific draft, you notice that those particular ones being blue, the ones we have spoken about before being black. So, May this 15th day of January 25 is the date clause. So, when I look at this now, the commencement has shown me this document is a power of attorney. The date clause is now disclosing that this power of attorney is to commence on the 15th day of what? January 2025. Now, I can also write it this way. This power of attorney is made this 14th day of February 2025. Now, I've told you there's option 1 and there is option 2. I told you that option 1 is when you know that power of attorney will not include a reciter. But the moment that power of attorney will include a reciter, use the option 2, which is why it now flows that this power of attorney is made. So the moment you see is made, it tells you that this power of attorney would include a reciter. So listen closely, if the examiner tells you that a reciter will be included and then it asks you to draft the introductory part, then you use option 2, because option 2 is best suitable when you know that the power of attorney will include a reciter clause, right? But if it will not include a reciter clause, then it will be by this power of attorney made this 15th day of January 2025. Or if it will include a reciter, this power of attorney is made this 14th day of February 2025. Please don't leave it undated. Don't leave it undated. This is not a deed of assignment. This is a power of attorney. I've told you that each legal document has its own principles. So you know the date to use. When no date is given in your scenario, use the day of your exam, right? So that you'll be on the safer side. These are very cheap mark areas. So don't allow all these simple technical aspects, rob you of what you could have earned. Let's look at the next clause, which is the recital. And then I already told you why it is in red. It is in red because not every power, it's not mandatory that every power of attorney must include a recital. No. Usually, as we are going to see, the necessity of including a recital usually comes up when you are empowering a donee to deal with a family land. And the nature of family land holding requires that the consent of the family head as well as the principal members are to be obtained before you can validly empower a donee to act on behalf of that family, which is the donor. That applies to every transaction that's to do with the family. The consent of the family head and that of principal members must have been first obtained. So how then do you show that that has been fully satisfied? That is where the recital now comes in. But you know that it is not every power of attorney that deals with family land, which is why you cannot say a recital must be present. But the moment it is dealing with a family land, it is best to include it in the recital. You recall that when you watch the tutorial video on the land registration law of Lagos State, one of the novelties in the Lagos State jurisdiction is that a sale will be rendered void or any instrument rendered void if the consent of the principal members and family head is not, obtained. How then do you disclose that has been obtained? You put it in the recital. So it is to acknowledge that all required consent has been obtained where the purpose is to administer the family land. And of course, the general function of a recital, which I already explained in the draft video on deed. It is that it is to help to it helps to interpret the background, purpose, and intent of the document. So it lets you know that okay, we are granting a power of attorney so that this donor can act on our behalf. Okay, we are the owners of the land. We have obtained the consent of the family head, and so it discloses it. It will help to interpret the background, the purpose, and the intent of the document. So I'm going to show you a sample draft of what a recital looks like when you are dealing with a family land. Let's look at the sample draft. The recital, which we learned on that deed, will always begin with what? Whereas. It will always begin whereas, written in capital letter. So don't forget that. It will always be written starting with whereas, then put colon. So whereas what? You want to now narrate, right? You want to narrate. You want to tell us, okay, the Adeyemizu family is the beneficial owner of the property situated at number 4, Alakoila Street, Blueview, Ikotun, Lagos State. Just use a fictitious name so that nobody will say, it's my family name, and they'll just use a fictitious address, right? Of course, this is just for educational purpose, right? So, in case your name is I don't know you. So, now, do you know that we have started to narrate now, right? So, anybody that is reading this document knows that, okay, this power of attorney is in respect, is from a family. That family is known as Adeyemizu family. And this family, they are the beneficial owner of the property, right? Then it now further disclosed that prior to the execution of this power of attorney, the unanimous consent and approval of the head of the Adeyemizu family and all principal members thereof were duly sought and obtained for the appointment of an attorney to manage and administer the said property for and on behalf of the family. So can you see that by including this in the recital, you are fully satisfied the requirement under the LRL of Lagos State that you should have obtained the consent of the family head and what principal members. You have disclosed this. So you are on a safer side. So that nobody will stand up years later to say the family head did not consent to the grant of the authority. You can just look at the recital. Recital is to clear ambiguity. And of course, it can be historical, it can be narrative. I've discussed the functions. I won't bore you with that in this video, right? So this is a sample draft on how the recital to a power of attorney could be drafted. So you can take note of that. Of course, if you are given a scenario, please stick with the family name that was given to you. So I'll just give you this one for free, right? Of course, you discuss it with your friends. The moment the scenario is about a family property and you are asked to draft the introductory part, please draft the power of attorney with a reciter. You won't be told. You may not be told they will just ask you. Maybe they've given you a scenario that okay, this also family has a land. They want to empower so person to do this. Now draft the introductory part. You should be smart to know that this land is family land. This person wants to be granted power of attorney. When you are drafting the introductory part, you draft the commencement, you draft the date, you include a reciter. In that reciter, recite the family. Just write it like this: the family of so is beneficial owner. Prior to this, you are good to go. It shows that you know what you are doing. That when it has to do with family land, you need to show that the consent of the family head and principal members have been what obtained. So that is all about the recital clause. Let's move on to the next clause, which is the appointment clause. And this is very simple and straightforward. The appointment clause is to show who has been appointed, right? Like as the name implies, appointment clause. Does that not capture the entire purpose of power of attorney? Is it not to appoint a donee to act on behalf of the donor, right? So the appointment clause, going further, it is that the clause helps to identify the party involved in the transaction. You notice I did not say parties because you know that a power of attorney is a deed poll executed by one party. The persons involved the donor and the donee are treated as one in the eye of the law. So what the appointment clause discloses is that it will help you identify the names of the persons that is the donor as well as the donee. Also, this particular clause is the clause that shows the appointment of the donee. So all this grammar that I'm just blowing around, let's look at the draft so that you see how it connects. So we'll begin. So what I'll be doing is I'll be showing you from the ones we have done, and then the ones in black are the ones we have done before. The ones in blue will reflect the ones that we are currently discussing. So by this power of attorney, made this 15th day of January 2015. Apparently, this one does not include a reciter, right? Now, look at the appointment clause. I, Aboyewa Ilemobayo Oluwaseun of number 1, Adiola Odieku, Ondo State, appoints Esther Joy of 12 Okeke Close, Alagomeji Yaba, Lagos State. So you can see that even if you don't know there's appointment clause, by looking at how this has been drafted, it shows you that this is an appointment clause. But notice that this appointment clause is disclosing the identity of the donor, which is Aboyewa Ilemobayo Oluwaseun, and also disclosing the identity of the donee, which is what? Esther Joy. But notice that this main word appoint is in capital letter. So please ensure you put it in capital letter. You see, this power of attorney is a very simple topic. So don't be too excited when you're writing and then you forget all these simple and technical areas that may rob you of your mark. So the function of the appointment clause is to disclose the identity of the party involved in the transaction. It will also show that this donor has been appointed. So that is the function of the appointment clause. Let's move to the next clause. Now, in case you are asking, what if the donor is a company? Then watch the video again on that I showed you how to draft the various persons that may be involved in a transaction. That's what you're going to apply. If it's a company that is a donor, that's how you will draft it. But here we are using that of a natural person. So this one is I, Aboyewa Ilemobayo Oluwaseun of number. This is just how to draft it for a natural person. What if it was a company? There's how to draft it. The link to that video is attached to, check it under the link of this video, and then you watch how it should be drafted. Moving on, the next clause is the power clause. Yes, this is the power clause. This is the power of attorney. So this is the power clause. Now, what the power clause does, we now know the nature of the document. we have been able to see the day of the commencement of authority. We've been able to, if it was supposed to include a reciter, it has been included. If it was supposed to, of course, it will include an appointment clause. The appointment clause has disclosed the identity of the donor as well as the donee. What the power clause now does is to define the scope of the authority of the donee. No, power of attorney is not just to say, I hereby appoint you as my attorney, right? And then that's just all to that. No, you need to be specific. What are the powers of the donee? What can the donee do? And what can the donee not do? That is where the power clause comes in. So it helps define the scope of authority of the donee. So, do you want the donee to sign a document on your behalf? You state it. I'm going to show you various power clauses that you'll see in your examination questions as we proceed. So, don't let me jump ahead of myself. Also, it will also help to determine the mode of revocation. You know, the power of attorney, the power clause especially, it will let you know if the action or the power being donated is the one to be carried out by deed, or or that the law requires to be by way of deed, right? Or the one that the law does not require to be by way of deed. For example, if I say that Esther Joy is appointed to, you know, sign a deed of assignment. Signing a deed of assignment must be by the deed of assignment itself is by way of deed. So if I want to revoke that power, what do you think I'll revoke? I have to revoke it by way of deed because the power is showing that I'm asking Esther Joy to do something that is ordinarily by way of deed. So the power clause can help you to determine the mode of revocation. You're going to understand it better the moment I start showing you all the various examples of the power clauses that we have. But let's look at the draft. How do you draft the power clause of a power of attorney? So, by this power of attorney, made this dash day of dash 2025, I, Aboyiwa Lumbayo Oluwaseun, of number 1. So, we have the date already, right? The appointment clause. It has appointed Esther Joy of 12 Okeke Close, Alagomeji Yaba State, right? Then, what you want to see now is the power clause. How do you draft the power clause? To be my lawful attorney, and in my name and on my behalf to do all and any of the following acts. You can even see that when you look at the way it has been rendered, it's even very straightforward. That I am appointing Esther Joy to be my lawful attorney, and that in my name and on my behalf, she's empowered to do all or any of the following acts. I'm only explaining, this is how you will draft it. To be my lawful, let's go again. To be my lawful attorney, and in my name and on my behalf to do all and any of the following acts. Then you list those acts. 1, 2, 3. Or you can use A, B, C. So, how do I know what to list? If I'm asked to draft the power clause of a power of attorney and the scenario was given to me, how do I know the power clause to list? You look at the document, you look at the scenario. What did the scenario tell you that the donor wanted to ask the donee to do? That's what you will include in the power clause. So don't just leave it blank, right? You be specific. So let's look at some of these power clauses that may be included in your scenario. So please, this is how to draft the power clause. But let's see some of the power clause that may be included in your scenario. The scenario may tell you that the donor, it won't tell you donor, right? It will just mention the generic name. Because of your understanding of power of attorney, you will be able to know that, okay, this particular person being mentioned is the donor. He wants to transfer, he wants the donee to be able to transfer the unexpired residue of his 4-bedroom duplex at 9 Misha Street, Mitama, covered by a certificate of occupancy, registered as number 11, page 34, volume 20131 to Duplex Nigeria Limited for the sum of 35 million naira. You know that the power clause is disclosing the sale of land transaction because it transferred unexpired residue. Of course, when you watch the module 1 of this tutorial class, I copiously explained how to, identify, even if you close your eyes, you will know how to identify that this particular statement is disclosing its particular transaction. So this sale of land now is by way of deed, right? So you'll be able to know that, okay, if this power is to be revoked, it must be revoked by way of deed. So when you see this, for example, listed in your question, right, and you are told to draft the power clause to that power of attorney, you include this because this is the power clause. It's telling you what the donee is to do. It could also be to grant a term of 12 years lease of my warehouse at plot 1218 Olu Ilupeju Industrial Layout Lagos to Mr. Samuel Aremu. This is a lease, right? A grant of term of 12 years, right? 12 years, right? This is a lease. And then also it could be to obtain a loan. So I'm just showing you the various things that the donor may want the donee to do on his behalf, right? And usually because the syllabus is focused on land transactions, these are the likely, power clauses that will be included in your scenario that the donee is to be empowered to carry out. So that any question that now follows that, okay, what is the mode of revocation? You know that if you are asking somebody to obtain a loan of 55 million naira, you are talking about a mortgage transaction. So definitely the mode of revocation has to be by way of deed. If it's about a lease, it has to be by way of deed. It's about sale of land, it has to be by way of deed, right? So also, it could be that it is to execute a deed of gift to transfer my ownership of the two-bedroom bungalows at number 14 Rumukoro Street, Port Harcourt, Rivers State to my son, Mr. Emeka Okoro. This is a gift inter vivos, which is supposed to be by way of deed. So they could also be to pay the outstanding land use charge, right, for the year 2022 and 2023 of my property at number 15 Awolowo Road, Ikoyi, Lagos, and to obtain the official clearance certificate. Of course, this is about general powers relating to management of properties. So, like this number 6 now, unlike the ones we have been seeing, right? This one can be revoked in mere writing because you can see that this power is just about management. It has nothing to do with if somebody is to collect rent or to pay land use charge. That is not by way of deed, right? So this power clause shows you the various, powers that the donor may empower the donee to carry out on his behalf. So, what I'm going to do now is let me take you back to seeing how the power clause is to be drafted so that you can refresh your memory and not forget so easily. Okay, so it is to be my, I want to also start, to be my lawful attorney and in my name and on my behalf to do all and any of the following acts. Then you list those acts, which is what we have just mentioned in the power clause examples that I have mentioned. So let's look at the next clause, which is the omnibus clause. The omnibus clause. What is the function of the omnibus clause? The omnibus clause, of course, which directly follows the power clause, it authorizes the donee to do acts reasonably necessary. That's what I want you to pay attention to. Reasonably necessary to give full effect to the powers expressly granted. So you can see these two highlights that I've done now. The reason for the omnibus clause, which I said that it follows the power clause, the omnibus clause is authorizing the donee to do acts that are reasonably necessary to give full effect to the powers expressly granted. Now, you know the Ujus then generis rule, right? That is present in the mode of interpretation of the power of attorney, right? Where a general word, right, is followed by a specific thing. That general word will be interpreted to include only the things of the same type as those that have been listed. So, for example, the power clause said that the donee should collect rent from tenants. Now, does collecting rent include slapping tenants? No. But does collecting rent, can the donee serve a notice to the tenant to remind them that you are supposed to have paid your rent? Yes, the act of serving them a notice may not have been expressly mentioned in the power of attorney power clause, but serving that notice to remind them is a way to ensure that that collection of rent is possible, right? If the donor, for example, says, donee, buy a land on my behalf, that power clause does not include the donee going to go and obtain loan at all. You say, but the loan is to effect. No, the loan is going to create another transaction entirely. Don't forget, the purpose of the instruction is what? Buy this land for me. That's a sale of land. But if you go ahead to go and borrow loan so that you can buy the land, you are going to create another transaction entirely. So the act of obtaining loan for the purpose of purchasing the land, you have gone outside of the scope of what you could have done to reasonably give full effect to the powers expressly granted. So the purpose of the omnibus clause is just to say, you know what, even if I did not mention that you can do this, but if you do it, it is so that the power I've given you can be achieved. So let's look at how this is to be drafted. We have, our commencement clause followed by the date clause. We have our appointment clause, which is disclosing the donor as well as the identity of the donee. And you notice that the full particulars of the donor and donees has been disclosed. And then it is followed by the power clause, which is that I want you to be my lawful attorney in my name, on my behalf, do all and any of the following acts. Now you have listed those acts. Then the omnibus clause now says, and to do all things necessary or incidental to the matters above as I may lawfully do. So you can see the matters above is this A, B. So if the matter A, if the power above is to collect rent, right, from my tenant at so property, what are the things necessary that you can do? Which was what I mentioned earlier. If you issue them a notice to pay, what you have done by issuing notice is incidental to seeing that the collection of rent is made possible. But it does not include you now harassing or slapping the tenant. How does slapping the tenant help you to achieve collecting the rent? You can say that there are two words apart. So the omnibus clause is only giving rights to the donee to do certain acts that will help the power clause, that power clause itself, to be achievable. That is the function of a omnibus clause. Let's move to the next clause, which is the irrevocability clause. This is a very, very sensitive area in our discussion on power of attorney, being that a power of attorney may be revoked expressly in three ways: expressly, impliedly, and by the operation of law. When we say that a power of attorney is revoked expressly, that means that it is either revoked in the mode in which it was created or by another higher means. So if a power of attorney was made in mere writing, it can be revoked in mere writing or by deed. If a power of attorney is made by deed, it must be revoked by deed. You cannot revoke it in mere writing. The next mode of revocation is the revocation, that implied revocation. Why? Because when you remember the case of Shime and Shime, the court held that the fact that the donor has granted power to the donee does not stop the donor from still carrying out the same acts that he has empowered the donee to do. The next mode of revocation is the one that is by the operation of law, which says that if for any reason the donor suffers from any legal disability, for example, death, bankruptcy, insanity, the power given to the donee becomes automatically revocable. It becomes automatically revoked. That's what we mean by operation of law. That is, once you do A, you get B. Once you add 1 plus 1, it must be equal to 2. That's operation of law. Once this takes place, this is what follows. You will notice that this would occasion hardship on the donor or third party dealing with it will occasion hardship on the donee rather, or third party dealing with the donee. So the way to circumvent this strict provision of law, especially that implied revocation and operation of law, is to create an irrevocable power of attorney. Why? Because generally a power of attorney is revocable. It is revocable, right? So the way to now prevent or circumvent that operation of law is by including this irrevocability clause. So this clause will prevent, let's start with the first function. It will prevent the donor from unilaterally revoking the power of attorney once it has been granted. That's one of the first function of this irrevocability clause. It will prevent the donor from single-handedly revoking the power. Don't forget that generally it can revoke. It can revoke expressly, it can revoke impliedly. The operation of law is beyond his control. Once that one happens to him, that's all. But the moment a power of attorney is made irrevocable, then the donor cannot wake up one day to just say, I hereby, no, there has to be mutual understanding between the donor and the donee to know that, okay, we now want to revoke this power. The donor cannot even say, okay, I still have the power, I can still do it. No, you have already made this power of attorney irrevocable. So it will not, you cannot imply it, you cannot use implied revocation. You can also use express revocation. There has to be mutual understanding between the donor and the donee before that power can be revoked. So the irrevocability clause, it prevents the donor from unilaterally revoking the power of attorney once it has been granted. So of course, it will help prevent competing sales. That's what implied revocation causes. If the power can be done by the donor and the donee, it can lead to two different competing sale and interest that may arise in the exercise of that power of attorney. The next thing is that it protects the interest of the donee or any third party, especially where the power of attorney is given for valuable consideration or is coupled with an interest. Now, this one is just in a way to stylishly tell you that the power of attorney may be created to be irrevocable because where the power of attorney is coupled with a grant or an interest, and then it has been expressed to be irrevocable, or it was coupled with valuable consideration and expressed to be irrevocable. So the moment, for example, the donee paid the donor to gain that power of attorney, it's possible to do that. For example, for government land holdings, that is land that are held by the government, you can approach the government and say, what, authorize me to be able to deal with this property for the period of 15 years. Then the government will ask you to pay 50 million or pay 20 million. Then you pay. When you pay, you must ensure that you tell your lawyer that, see, I paid for this power of attorney. Then your lawyer will tell you, then it should be made to be irrevocable because it was coupled with an interest, right? Or you gave it for valuable, that falls on that, you gave it for valuable consideration. But what if maybe the donor was owing you, and then because he's owing you, that's when he now said, okay, let me give you this power of attorney. That's when it is coupled with an interest. But if you pay for it, that is when it was coupled with what? Valuable consideration. I will say it again so that you may not need to ask, that maybe you are confused. When is it coupled with interest? When is it for valuable consideration? If you pay for the power of attorney, it is coupled with valuable consideration. But if, for example, it was made in settlement of debts, that is, the donor is owing you, in order to repay, he now granted you power of attorney so that you can be dealing with the property, then it was coupled with an interest, then expressed to be irrevocable. So that is one of the function of the irrevocability clause. Also, finally, it ensures that the authority granted is not terminated by the subsequent incapacity or legal disability of the donor, which was what we were trying to explain when we started discussing on the irrevocability clause. If the donor dies, then the date and time, month, seconds of his death is when, by operation of law, the power granted is terminated. But what if the donee is acting, and he's not even aware? This is where the irrevocability clause comes in to protect him. It will ensure that even though the donor rather goes bankrupt, becomes insane, or death takes place, the power granted will still be subsisting. Because if the donor, for example, let me use a very practical example. If by power of attorney, a donor has been appointed to act for the donor, and it was not made irrevocable. If the donor died yesterday, then the donor, unaware, sold a plot of land that same day, that sale is null and void, because the moment that donor dies, only the executor, that is if he has a will, only the executors of that donor in quotes, which is now the testator, can deal with that testator slash donor. Understand what I'm trying to say? The property. But where there is the irrevocability clause, even though the donor dies, that irrevocability clause will protect the donee to still carry out and go on with exercising that power, especially when there is a time frame. Don't forget, there's always a time frame that may have been stated for the power of attorney. So let's look at how the irrevocability clause is to be drafted. We have the commencement, our date. We are doing this so that you can understand. Of course, this will also help you memorization. I'm also going to post a video where we are going to be learning this together so that you can memorize it, right? So let me just skip this. We have this already. We have the omnibus clause, right? So how then do you write the irrevocability clause? Now, the example I'm giving you now is the one that says that a power of attorney is stated to be irrevocable for a specified period of time. When you watch the main tutorial video, I already showed you how you will draft the one coupled with an interest and the one given for valuable consideration. So let's focus on the one stated to be irrevocable for a specific period not exceeding 12 calendar months. It is declared that this power of attorney shall be and remain irrevocable for a period of 10 months from the date of its execution. So what does that imply? If the donor dies within these 10 months, the donor can go on to carry out the power. If the donor rather, if the donor becomes insane, if the donor becomes bankrupt, the donor can go ahead to still exercise the power clause of the power of attorney. So you can see the advantage of this irrevocability clause. This is how it is drafted. It is declared that this power of attorney shall be and remain. So you can see very clear, shall be and remain irrevocable for a period of 10 months from the date of its execution. Let's look at the next clause, which is the testimonium. So at this point, we have started to wind down rather, on our discussion on power of attorney, because when you start discussing the concluding part of any deed, I mean, you are done. There's really nothing much to talk about, right? The testimonium simply links the document to the donor, right? It lets you know that, okay, oh, this document, oh, right, whatever you have seen in the introductory part and the operative part and the miscellaneous part, it is the donor that has empowered the donee. Everything you have seen so far, it is the donor, because it will link the execution clause, link it to every other part of the document. So let's see how it is drafted, which is the same thing under deed, right? It is in witness of which I, the donor, have as executed this power of attorney in the manner below, the day and year first above written. So you can see even the draft shows you in witness of which. What are you witnessing? Everything you have written since commencement date, recital, your power, your appointment clause, your power clause, omnibus clause, the irrevocability clause, you are witnessing to it that, see, oh, I was the one who authorized. So the donor is simply confirming. So you can see testimonium is linking the document to the donor. So this is how to draft it. In witness of which I has executed this power of attorney. Please don't write executed this deed. You must be specific, because this deed is specific. This power of attorney. If it was deed of assignment, we'll have said this is of assignment. Of course, it will not have been donor, it will have been assigned, no, right? So ensure that you take note of these very simple parts. So in witness of which I, the donor, has executed this power of attorney in the manner below, the day and year first above written. So let's look at the next clause, which is the execution clause. Execution is also another thing for what? Signature, right? So whose signature should be on the power of attorney? It is the signature of the donor, which we have explained copiously in the main tutorial video. So let's look at the draft. Of course, what about signature? So that the donor cannot say, it was not me. once you allege forgery, if somebody is saying my signature was forged, you want to prove. You allege must what must prove, and you assert you prove, right? So the signature is to show that the donor indeed is the one who granted the powers to the donee. And of course, you first write your testimonium. When you are done writing your testimonium, then you draft the execution clause as signed, sealed, and delivered by the within named donor. What if the power of attorney was not to carry out any power required to be by deed, then to be signed and delivered? But the moment it is by way of deed, because you have looked at the power clause is asking the donee to do something by way of deed, then it must be signed, sealed, and delivered by the within named donor. And of course, you write dash, and you must ensure, please, that you sign. You must sign. So don't leave it. And then, of course, you include the name of the donor. So you must sign. Tell yourself you must sign. Don't leave it. To if you leave it, that is zero, right? Because if you don't sign, then don't forget, a paper that is not signed is what? A document that is not signed is what? Is a worthless piece of paper. So that's how the examiner will also treat your paper too. That this particular question, no, this is worthless because there's no signature on it, right? So ensure you include your signature. Don't forget what I've just said now. How do you know when to use signed, sealed, and delivered? Ask yourself, what is in the power clause? Is the power clause asking the donor to do anything by deed? Then it must be signed, sealed, and delivered. But what if it's just general property management? Then you can say signed and delivered. Do we need the execution of the donee? No. Only in certain jurisdictions like Lagos State. But don't bore yourself with that. Especially when the question is not talking about that, so that you don't confuse yourself. Okay, when should I include the execution of the donee? If this the narrow is now more specific about, that land registration law, how you can implement it and effect it, then you can talk about that, right? But if you are simply asked to draft the execution clause, you draft it only for the donor. So let's move to the next clause, which is the attestation clause. What is the purpose of attestation? If somebody is attesting to a fact, it is simply saying, I witnessed it. What is the essence of somebody saying, I witnessed it? It's to strengthen or prove due execution. So that, execution goes to the root of validity. Such that if for any reason the power of the donor is being contested, then then somebody who attested to it can say, I witnessed the donor signing. It will strengthen the proof of the execution clause, right? So when it comes to power of attorney, what are the salient points to take note of when it comes to the attestation clause? The first is that where a power of attorney is to be used outside of the country of its creation, it must be attested to by a notary public. A notary public is generally accepted, right, all across. So you ensure that you use a notary public so that that document becomes valid, right, and acceptable for use in that other country. Of course, what if you don't follow that? The law says you should regularize that document by doing the right thing. When you regularize something, that means you do the right thing that you should have done. So when the power of attorney is to be used outside of the country of creation, how would you know is to be used outside of the country of creation? The scenario will disclose that Mr. So 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 and so lives in London and is contacting you that you are in Nigeria, that he in London wants to empower you to carry out certain acts for him in Nigeria. You can see that then he's asking you to say, okay, they're not asking you draft the power of attorney. Apparently, is to be used as a state of creation. Or the power of attorney is saying, okay, do this so and so in London. Do so. You can look at the power clause or look at the scenario to be able to identify if this is to be used outside of the state of creation. But this is the best bet. What you can always do, whether you are confused, if you are confused, is it to be used in the state of creation, outside of the country of creation? Just when you are dealing with power of attorney, just make your attesting witness as a notary public. So that just saves you the stress. So if you are going to be asking me, so sir, how do we know when we have to use notary public? How do we? The answer I'll just give you is, why don't you just use notary public anytime they are testing power of attorney? Because it just put on the safer side. Whether you know or you don't know, the examiner also does not know, right? So you are able to say, okay, notary public as the attesting witness. So that saves you the stress. You know the provisions of section 150 of the Evidence Act that says that a power of attorney is presumed to have been made validly, like that it will like to for the purpose of authenticity. If you if the president, a the president, a notary public, a magistrate, a justice of the peace attest to the power of attorney, it gives a presumption of authenticity that it was duly executed, right? When you allow this specified group of persons mentioned under section 150 of the Evidence Act 2011 to be the attesting witness to the power of attorney. So, how do you draft the attestation clause? No, this is the testimonium, right? You have the execution clause. Don't forget, you have to ensure that you sign. So let me give you that sign again so that you record that you are supposed to what to sign, and then you include the name of the donor. Then what follows is the attestation clause. In the presence of, you are saying that this signature took place in the presence of. Then you have your name, you have your address, the address, then you have the occupation, right? And then you have the signature. And what did we say just now? It is advised you better use a notary public, right, to be the attesting witness, so that whether you know if the scenario is about use outside of the country of creation, use within the state of creation, you're on the safer side. So these are the things to take note of when discussing drafts on power of attorney. So far now, we have been able to discuss the function of each of the clauses, right? Now you know the date, the commencement clause, the date, the recital, the appointment clause, the power clause, the omnibus clause, the irrevocability clause, the testimonium, the execution, the attestation clause, as well as the franking. Of course, for the franking, it's just for you to say prepared by, right? When you watch the lecture video, the drafting video on Did, right, and also on Wheels, I showed you how to draft. So please go and watch that video to see how to draft the franking aspect of any document. It's just simple. It's just you as a lawyer disclosing that you were the one who drafted or prepared that particular document. So thank you very much for watching. Ensure you recommend this video to your friends, and please ensure you subscribe all across our social media platforms. We're on TikTok, we're on Instagram, we're on Facebook, right? Please ensure you subscribe and also invite your colleagues to watch this video. Tell them what you learned. And also, like I told you, there is a memorization video on the platform. Ensure that you watch it so that you're able to train yourself so that you can recollect how to draft these property law, documents as may be required of you in your examination. So I'll see you in the next drafting class video.